The Corporate Transparency Act's reporting requirements are back again after being off again after a recent court ruling. If you own a business, you're going to need to pay attention. Now, the deadline for most companies is back to being March 21st, 2025, if your deadline has already been passed or if it was coming up. But further changes are going to be on the way. Hi, I'm John Strohmeyer with Strohmeyer Law, where we help our clients leave no unfinished business. While I am a lawyer, I am not your lawyer, so don't take my advice, some talking head on the internet, to be applicable to your particular circumstances. You must talk to your own advisor about your particular situation if you want to get some good advice. Also, don't forget to like, comment, and subscribe. So today we're talking about the latest updates for the Corporate Transparency Act. We're recording this on February 20th, 2025, and we have had some changes this week. Why are we thinking about this? When we think about our four horsemen of the estate planning apocalypse, costs, delays, frustrations, and fights, we're dealing here with potential avoidable costs. Failing to comply with the beneficial ownership information reporting requirement deadlines could lead to some hefty penalties. I know a lot of people don't think this is going to be constitutional. We have had some rulings that said it is not constitutional. We also have had some rulings that have said that it is constitutional, which means err on the side of caution. You want to be putting yourself in the best position to avoid having to fight off penalties. So let's get into it. Top of the pile, these recent court rulings have put the Corporate Transparency Act reporting back into effect. Now, on Monday, February 17th of this week, 2025, the U.S. District Court in the Eastern District of Texas lifted its own injunction that had been blocking CTA enforcement, at least here in Texas. So this was Smith versus U.S. Department of Treasury. This followed a Supreme Court decision on January 23, 2025 in McHenry versus Texas Top Shop, Inc., which also lifted a separate injunction. In the interim, from that January 23rd until February 17th, FinCEN had been holding off saying, well, we're going to wait and see. Now, the bottom line is, at this point, beneficial ownership information reporting is once again mandatory. How do we know? Well, those court rulings then combined with reports from and notices from FinCEN. The new reporting deadline is March 21st, 2025. So FinCEN announced on February 19th, 2025, that most reporting companies are going to need to file by March 21st, 2025. This has been stacking up all of the prior deadlines. So if you were extended because it was an existing reporting company that existed before January 1, 2024, well, originally that due date was January 1, 2025. It's now been kicked out to March 21st, 2025. If you instead had an entity that was formed in 2024 and you had not already passed that due date, well, that's now been kicked out to March 21, 2025. If you formed in 2025, again, you're getting kicked out to probably the later of March 21st, 2025. Or if you had just formed it and you have that 30-day extension, well, then it could be later than March 21, 2025. Now, this is for those existing companies. What else is out there? We're also going to think about the normal exceptions we have for disaster relief. Normally, when there's a hurricane, major storms, flooding, something like that, the IRS, as part of following along with disaster declarations, will delay deadlines. We had the hurricanes here in Houston, Hurricane Beryl and the derecho back in 2024, which resulted in the income tax deadline, the extended deadline being February 3rd of 2025 to file your 2023 income tax return. So instead of the extended due date being October 15th, got pushed all the way out to February 3rd. Similar things are going to apply for CTA reporting. So businesses that have later deadlines due to disaster relief should follow those specific deadlines. Obviously, if you can get it done faster, do that. What else? Well, FinCEN has indicated that certain low-risk entities may still see delays in those deadline modifications. Right now, we don't know exactly what that means. What is a low-risk entity? I don't have any good guidance on that. It could be single-member entities. It could be entities that are already licensed by some other state board, like a law firm, something where Everybody is required to have a license from the state. So, CPA firm, maybe a medical practice, those could be low risk entities. The answer is we really just don't know yet, and we're going to have to wait and see. So, again, these revisions are potentially out there. What the goal is going to be is reducing compliance burden for lower risk. These potential regulatory changes could be a boon for lower risk entities if we ever figure out what they are. The problem is we're likely not going to get any guidance before that March 21st, 2025 deadline. What does that mean? If you haven't filed, you should be getting ready to file anyway. Don't wait. Don't take the risk that it's going to happen right at the deadline. Get it taken care of so you're not worried about getting in compliance right as the deadline's coming in. Well, what else could change? It's possible Congress may weigh in on this. Again, I wouldn't count on it. Kind of what else is swirling around there? We have a Republican controlled Congress and Senate and a Republican in the White House. We're expecting, but it hasn't happened yet, also extensions on tax relief for estate and gift tax. Well, the problem with this is that the Republicans have said that tax reform is not in their first 100 days priority. So who knows when we're going to get that? And alongside of that, who knows when they're actually going to get to extending or dealing with the CTA. Now, the House of Representatives has passed the Protect Small Business from Excessive Paperwork Act, H.R. 736. This would extend the filing deadlines for companies formed before January 1, 2024 to January 1, 2026. There's a companion bill in the Senate, but it's unclear if or when it will ever pass. Now, a few things on this. This only applies to those existing companies. These are the companies that would have been formed before January 1, 2024, meaning their original deadline was January 1, 2025. This bill, it didn't repeal or it won't repeal the CTA. It just kicks out the deadline by a year. So it doesn't matter that it's constitutional or not. Congress is pushing it through, almost saying, no, we think it's still constitutional. A Republican-controlled House has said, we're keeping this in place. And I think this is important to think about as you think about the CTA. It's probably not going anywhere for a host of reasons they're probably not going to say out loud. Now, really what that is that the financial system is looking to get these clamps down to stop people from abusing the financial system. There are going to be other people who have other conspiracy theories. I'm not peddling in that. What I am looking at is the banks probably want this to happen. And so while the courts may say it's unconstitutional to require any sort of filing deadline just for forming an entity, the law requires that the banks enforce and as part of their know your customer, know your client regulations, the provisions of the CTA. So think about it that way. You can go and form an entity and you may not have to file any of this. But the moment you try and open a bank account, that entity is going to have complied with the CTA for the bank to open an account. You're probably not going to find a bank that's willing to risk their own license opening a bank account without doing their own due diligence. It could happen, but I doubt it. So, what does this mean for your business? Top things, compliance is again being required. With the Smith ruling, corporate transparency reporting is back in effect. This means that businesses generally are going to have to meet the March 21, 2025 deadline unless an extension is granted or they had a later deadline for another reason. Going forward, entities are still going to have to file within 30 days of formation. That means if you're looking to form an entity, make sure you have the information ready to go before you file and don't be scrambling to get everything in afterwards. Thing two, think about further updates. FinCEN has said that they're going to be revising the reporting requirements and they may extend some other deadlines. We don't know what that's going to look like yet, but keep an eye out of it. FinCEN's announcements really do give you a lot to go off of. Could Congress do something? They could. They're considering an extension. Something has passed out of the House, but who knows if anything will move forward in the Senate. For now, I wouldn't assume that anything is coming from them to change it. So finally, that means if you need to comply, you should be getting your information together so you can get the filings done before it's due. Don't have that last minute panic to get everything done. Get your electronic filings in at the fincen.gov website. So to wrap everything up, Get on this now. CTA reporting is back and the clock is ticking. While changes may come, the safest approach is to beat that March 21st deadline so you're not worried about it. And if you have questions, make sure you're working with your own advisors. Finally, if you have questions, we can help you with general answers about deadlines and what the rules are, but we're not going to be able to provide any specific answers for you here. Thanks so much for watching. We'll see you next time.